Is it working yet? No.
All right, let's go on. What's going on, everybody? Welcome to another episode, G-Boot 2786. I'm Gavin Richard. This is Gavin Richard Presents live from my bedroom. I just like to chill tonight, so who's in the chat room? Say hello. All right, we're gonna kickstart things in a few minutes. So let me just load you guys with uh some of the articles you can read in the chat box. I also have a few in the description of the video that you're going to be checking out. Let me see. Let's see. Let's see. Hang with me, guys. All right. Stuff in. All right. All right, guys, I'm ready to begin. Welcome to another episode of G-Boot of Gavin Richard Presents on my channel, G-Boot 2786. We are live, and I'm coming at you with 5. Welcome again. Hope all is well on this beautiful Saturday night. I know the games aren't really worth a damn because everybody is being blown out. I saw Mississippi State was getting blown out by Auburn. I think the score was like 52-16. And then Nebraska has gotten their behinds whipped. I thought it was 47-0 by Ohio State. So games have not been really entertaining today. Anybody know if anybody out in Louisiana who might be at the Southern UAPB game? Let me know what the Southern score was if you guys follow Southern football. I'm trying to pull up this code article for a second. So
No, it's not. It's working perfectly fine. He infiltrated all right. He infiltrated to work.
oh, that's Professor Blacktruth. I was listening to him before I came on.
Every week, you need to be debriefed and deprogrammed. You get so much of the picture right now. Wait for it stuff.
So hold on a second. I'm trying to find Mr. Crump. Pull up the Louisiana criminal code. So we're talking about the Amber Guyger trial. It's been for those that aren't familiar with it. Last year, back in September of last year, I believe it was September 6th, Amber Guyger shot Botham John, a 26-year-old. Amber Guyger is 31, I believe, while he was in his own apartment. And her claim was that she thought that this was her apartment, these are her words, and she saw Botham John, and she saw the door was partially open, and she claims while she was opening the door, she saw this silhouette of this person standing and jumping around, and she shot him, killed him, thinking he was a burglar. After she said, "Let me see your hands." I'll get into the testimony in a minute, but brief story is she's claiming self-defense, that she feared for her life, and she killed this man. Now, initially, you have a black police chief out there who's a female. I believe the chief's name. Give me a second. You have a black police chief out there. This wasn't David Brown. This is Elisha Renee Hall. I believe, is the chief of police in Dallas, Texas now. And many of the people, most of the people were complaining because Amber Guyger wasn't charged immediately. And initially, there was a ruling by the chief, by the police, the Texas Rangers, that recommended she be charged with manslaughter. Now, it's my understanding it was the grand jury that came back with a murder indictment against Amber Guyger. And as such, they are started this past Monday with the murder trial. It's been going on since Monday. They actually had court today, this past Saturday, where the judge took some testimony outside of the jury from the defense witnesses that they were trying to call, especially expert witnesses. Now, as a lawyer, uh, as someone who believes in due process, someone does believe in the presumption of innocence, I do like to hear all of the evidence from and hear both sides of the story. That's just out of fairness. That's also, if I were in a in a predicament where I was a defendant, I would honestly want to have my point heard. So I do believe in hearing both sides of the story. But of course, from the outset, it is not a dispute that Amber Guyger killed Botham John. It is a well-known fact that she killed Botham John. The question is whether was she legally justified in killing Botham John. And I have listened to, and out being fair, I have not seen all every day, every moment of the trial, but I have seen video footage of it. I have tried to follow it when I'm at work and listening to it because it is interesting. And it's very important also for those that want to know how law works to actually watch, these court proceedings. Most of us, especially when I know when we were younger, when the O.J. Simpson case came on, we would follow that day and night because, and I'm not trying to stereotype our people, but brothers and sisters, we were home, we weren't, I'm not gonna say we weren't working, but jobs regularly we didn't have. And that was during the summer. I remember that when which was in 95, we watched and paid attention. We saw, if you paid any attention to it, how Johnny Cochran uh, and the rest of the Dream Team, the defense attorneys, blew the prosecution's case in smithereens, mainly because the witnesses that they had on there were proven liars, like Mark Furman. Evidence that they had was tampered. They also were able to prove through testimony on cross examination from the limousine, from the not the limousine driver, but the tow truck driver that took. How you doing, TT? That took OJ's Bronco. When he testified, he did not see any blood inside the Bronco. The impound detective at the LAPD even observed the Bronco, and she did not see any blood. And you can look up a book called Legacy of Deception. You guys need to check out that book and read that, and you're going to see how the LAPD, specifically certain members, tampered with evidence in the O.J. Simpson case to make him look guilty, and he wasn't. I don't care what anybody says. O.J. Simpson did not kill Nicole Brown Simpson and Ron Goldman because it just, first off, it was not possible in that limited amount of time for him to do that. But getting back to this case with Amber Guyger, I observed and I did watch her testimony. She testified yesterday. And before she testified, I believe outside the presence of the jury, they had what's called a 705 hearing, which is when you will allow expert testimony. Now, what, and I've been following the case. There's a black female judge, and she has been no nonsense. I've liked many of the things that she's done so far, as limiting the testimony of getting into. She also chewed out the DA who gave a press conference or interview despite her gag order stating no one should talk about the trial. She was visibly upset about it. She was also upset and went off on a reporter who walked in with their laptop playing music. and they should know better than doing that. Now, what was when I the expert testimony? This gentleman by the name of David Armstrong. I have the articles posted. David Armstrong is claiming that Amber Guyger, and he says this in his statement, in his testimony. Now, this was outside the presence of the jury. She stated, he stated, excuse me, that Amber Guyger may not have had a normal perception in the tense situation. And it was his position. He said this, that he believed that she was not criminally liable for anything that happened. In other words, he was saying she was not guilty. And he was also, as I was listening to him, and I was very he giving testimony as if he is in Amber Guyger's shoes, which is something he cannot do, and rightfully so. The judge in this case, she said he could not testify as to the state of mind of Amber Guyger because he is basically trying to say, well, if I was her, I would have done the same thing, or I think she did reasonably. You don't know what she was thinking. You are speculating at that point, and correctfully so. I was listening today. This was the recap. I can't think of the criminal defense attorney's name, but he was saying that you're a foot soldier, and he was talking about the David Armstrong fella. And interesting enough, I'm reading here. You can go on TV1.com, news1.com. I have the article in the chat box. This same Texas Ranger has been charged, or was not charged, but was accused of killing someone in a high-speed incident. He was speeding. His name was yes, this is David Armstrong. TT called him an Uncle Tom. Definitely, what I think definitely he will be in on Fox News if Amber Guyger gets acquitted. He'll definitely get a spot. Now, and I understand police officers have a job to do, but you got to remember something. Their duty is to investigate. You investigate a crime based off the circumstances. And it was clear that this man, was trying to, from his testimony, take up for the defendant. And of course, the defense attorneys want that testimony in because if you have a police officer saying, a Texas Ranger, the state police, stating that her actions were reasonable and he didn't believe she should be charged with the crime. Well, the jury hears that. Of course, they may vote likely not guilty because, in fact, she fired and killed Botham John in self-defense. Now, this is what the Model Penal Code says about mistake effect. And Amber Guyger's defense initially was, I thought this was my apartment. So she thought this was her apartment, that there was a burglar that came in, and in self-defense, she's claiming Botham John, and this was on her testimony. I was listening. Botham John came at her after she said, "Let me see your hands. Let me see your hands." And he says, "Hey, hey, hey." And as he's approaching her, she fires 2 shots, a double tap, as the prosecutors state. Now, what was further interesting in her testimony, she talked about CPR. She admitted she didn't give him CPR, but what she said was, I did a little CPR. But we don't know what and the prosecutor was getting on that. Well, what's a little CPR? She said, I just gave him a little bit of, CPR, to which the prosecutor says, well, why don't you have any blood on your hands and on your clothes and so forth, which is very interesting. But, she said, I don't know CPR, but they, as police officers, they are trained. They are trained to know CPR. And then plus she's texting Martin Rivera, who is her lover. And she talked about how, and that's another thing, it's a credibility issue. She said they weren't going to have sex. It wasn't sexting, but yet you're sending the relationship was over, but yet you're getting explicit images, explicit text detailing of a sexual nature. Pretty graphic. So I don't, it's really ridiculous uh, as to what she's saying. And some of the things she was saying did not ring right. Yes, now this is what mistake of fact means. It means it is a defense to prosecution that the actor, though mistake formed a reasonable belief about a matter of fact, if his mistaken belief negated the kind of culpability required for commission of the offense. Although an actor's mistake of fact may constitute a defense to the offense charge, he may nevertheless be convicted of any lesser included offense of which he would be guilty if the fact were as he believed. Now, let me give you an example of what mistake of fact means. If you go into a grocery store and you purchase or you grab 10 items that you put in your bag, and when you go to the cash register at Walmart, for instance, let's say you put all but 10 items on the conveyor belt. And let's say you buy 2 cans of cream corn, the same kind. And the cash register, the cashier will go ahead and start marking your items. And when when she leaves one item off by mistake, she didn't know what she thought she did it, and you thought you did it, or you probably weren't even paying attention to it. You say, "What's my total?" And the total comes up. You pay it, the receipt comes in there, you grab your items, and you're walking out at Walmart. And this is a perfect example. Now, let's say, for instance, one of those items that you thought you purchased falls out into the basket that you're pushing, and you get stopped by a Walmart greeter. And there's a reason why I'm mentioning unbagged item is because Walmart greeters typically will and I had this happen to me. When you buy an item and that item isn't bagged, they will ask you for your receipt. And let's say you present your receipt to them and they look and they notice that, well, it says here you had 2 cans of cream corn and only one is marked. Well, you might argue, well, it was on the conveyor belt. She had it, she ran it up. She's like, no, we didn't. We're going to talk to loss prevention. Well, they go back and look and they see that all of your items on the conveyor belt, uh, and the cashier just failed to ring it up. Well, because you were walking out with that item, they could not charge you with theft because it was a mistake of fact. You did not have the specific intent to deprive Walmart of that item. And that's what the definition of theft is. And when it comes to this thing with Geiger, they're trying to say because she thought this was her apartment that she mistook it. She did not have the mental intent to commit murder. That's what they're trying to say. And they're also saying because she thought it was her, that's because in that state of mind, this is her apartment, she has no duty to retreat. And so she had every right to shoot this big individual coming towards her. And he actually used the terms big. And of course, we know big is another word for black because they can't mention race in these cases before court. O.J. Simpson case really changed all of that. And of course, they have to make the victim look like the perp. The problem with the mistake of fact defense that they're throwing and and the castle doctrine that they are likely trying to apply here is that this was Botham Jean's house. That's the fact. He had every right, if someone came into his apartment, because this is his apartment, he had every right, if someone came in there unannounced, startling him, he had every right to confront her. And he had every right to confront any person, just like any homeowner would. In any case, he had the right to stand his ground. And it's hard for me, even as an attorney, to get around that aspect. I could see you getting off on the wrong floor. But when you go to a door and the door has a red mat right before it, something you don't have, that's clearly not your house. You see this door slightly cracked. The door, you go in there with your gun drawn. You don't call for backup. You didn't even announce you were a cop when you walked in there. Now, had she done that, maybe Botham John would have reacted differently. Maybe he would still be alive if she says, freeze police. Now, of course, she was off duty at this point, and I go and speaking of being off duty, she knew after 12 hours when the clock out, she knew where her apartment building was. She went through correct basic things, but then all of a sudden, when you get to the wrong apartment, you get to the wrong garage floor of the garage, and you're on the wrong floor. You're saying you tune out and don't know any better. You don't know where you're going. You're saying, I'm focused here. I'm believing this is my apartment. And you know as well as I do, most people know that um, you recognize and know your home, especially if you've been situated there for a long time. Yeah, I do believe it's possible people get on the wrong floor. It happens all the time. Yeah. And they're saying the garage floors weren't numbered. And I've heard stories of people, they talk about it happening before. They've actually brought witnesses about that. However, those witnesses are still alive. They weren't shot in their home like both of John was. And that might be a reason also, coupled with the failure of the CPR of the criminal negligence homicide that she would be charged with as well. She could be found guilty of, because what happens is that there is what's called responsive verdicts, where if they can't get her on the murder charge, which would prove the specific intent, they can definitely get her on manslaughter or negligent homicide, because while she was there, and I believe she even admitted she could have done more from the evidence to save both of John's life, especially with CPR, the fact that she was texting all the time. The other fact that comes to mind is that you fired two shots. You didn't give him a chance really to, it sounds from the testimony, to at least defend himself or at least de-escalate the situation. And I wouldn't be surprised. And of course, you have blacks on the jury. There are five blacks, I believe. There are uh, a few Hispanic, and the rest are white, if I'm not mistaken. Let me look up the jury pool for you guys. The judge, by the way, in the case is Judge Tammy Kemp. She's been great so far. Uh, she's been no nonsense, and she's been limiting these expert witnesses like Craig Miller, who's a former police chief, and David Armstrong. And Craig Miller as a police chief, he's saying the same thing, that she was not liable for her actions, or she shouldn't be held liable. He talks about inattentional blindness as a defense. And again, the judge is going to allow testimony from these two experts, but she's limiting it. And don't be surprised if Amber Guyger gets convicted, that the defense attorneys in the case would try and appeal it or ask for a motion for a new trial based off of that testimony that should have came in, that they will argue, because what they've done is they've proffered before the court. Now, and proffering means when the judge doesn't allow evidence to be heard before a jury, but she can hear it in open court or in camera with the court reporter there, so it's there for the record. So, and I know the attorneys for Botham John, uh, you know, Darrell Washington, who's a good brother. Of course, Benjamin Crump and Esley Merritt have been there as well. Though, from what I know, is Benjamin Crump really, he's just the face. He'll be there for the national stuff. But I'm not saying the brother is not involved. I don't know, but we know Benjamin Crump because he's been involved practically in every police shooting, major shooting of any black person. He's been there, and some people complain because we don't get any victories out of it. But he's bringing attention to it. So here's a prosecutor, Jason Hermas. He's with the state. Botham John's sister testified, Alyssa Finley. I didn't see her, but she testified as to why marijuana was in the house, which was used to treat his ADHD. Now she was claiming she was, Hermes is also saying that, denouncing the claim that she was tired because they're texting with each other. Martin Rivera, her partner, and they're talking about a sexting message that was made before uh, the shooting, and make it look like it seemed like Amber Guyger, not make it look like, was trying to have a sexual meetup with Martin Rivera again, even though she's claiming that it had broken up, and it's hard to believe her. But the racial makeup of the jury so far: five black jurors, five Hispanic, Asian, two white, two black, and two white alternates. So it is predominantly people of color, but we do know, especially, and Tariq Nasheed brought this up, that when you can deal with Hispanic people in the Hispanic community, they will try and identify as white. Even immigrants who come over into America, they come. I'm just looking at Vulcan's comment. Vulcan 2050 full says Coon strong. Yeah, a Twinkie defense. You're saying the same thing that Professor Black, I'm sorry, Jason Black was saying tonight about the Twinkie defense. That came from the Harvey Milk trial, where Harvey Milk was murdered. He was the gay mayor out in San Francisco, and the man that shot him, David Morse, I believe. He also shot another gentleman. Um, they tried to say he had depression, and they weren't saying eating all of the Twinkies were uh, a defense, but what they were saying was that he suffered diminished capacity. And of course, with murder, you have to have what's called mens rea, the intent to inflict serious bodily injury or to kill. And what they're saying is that sugary foods was said to be a symptom of his depression, and he was convicted of manslaughter. No, the gentleman was not. It was Dan White. I'm sorry, I said Morse. No, Dan White, and Harvey Milk was. He was a San Francisco city supervisor. The mayor was George Moscone, and Moscone was murdered along with Harvey White on the same day. And of course, yeah, it was so unbelievable what they're saying, because Castle Doctrine. You think of Castle Doctrine, that stands for, comes from the old term of an Englishman's home is his castle. A man's house is his castle. That's the old saying. And you don't have a duty to retreat in most jurisdictions in your home. Even in Louisiana, we do have stand your ground, which is something different. But stand your ground means even in a place that's public. So you're talking about a public park where you have a right to be, as well as another person. If someone attacks you and tries to kill, came at you with a knife or gun, and you pull a gun first and you shot them after they pulled it, like you uh, believed your life was in danger, reasonably believing that, then that's stand your ground. And of course, you're familiar with that with the Zimmerman case. The problem was that, though, the person who had the right to stand his ground was not George Zimmerman, but Trayvon Martin, because Trayvon was walking to his house as Zimmerman was stalking him. And of course, I don't believe the state did a great job, even with that case, in defending Trayvon. And, the defense, of course, demonizing Trayvon Martin as this big thug that was harming this pudgy white man who George Zimmerman wasn't even that fat back then, but he's bloated now. And it was I was not shocked that they acquitted him and charged self defense, but what they tried to say was that Trayvon was the cause of his own death, and people were upset, obviously. And I remember when that verdict was read, everyone was upset over what happened because we knew what the deal was, and I knew from the fact that how long it was taking that they were going to walk, especially the makeup of the jurors. Six jurors on that trial. I think it was all female, if I'm not mistaken, and all were white except one who was Hispanic. They had booked. One of them had a book deal that was going to go down, but that book deal got canceled because of pressure. And I'll never forget, one of them went on CNN in the silhouette, and I was just hoping that someone would put the light on that person to see who this fucking bumpkin was that voted this man guilty. And what's interesting is that State Attorney General of Florida, do you know that she has publicly stated that O.J. Simpson is not welcomed in the state of Florida, but yet George Zimmerman, who we know murdered and killed Trayvon Martin, he's running around. He's been charged with domestic violence incidents, multiple ones. Of course, he's gotten off of them, but she had no problem, didn't mention his name. Ashley Moody is the AG in first 2019, and I believe her predecessor, so she wasn't the AG, but whoever the AG was, let's see, her predecessor was Pam Bondi. She was the Republican Florida Attorney General. And yeah, so yeah, she made that statement about O.J. Simpson is not welcome, but she has no problem with George Zimmerman being there. So I'm glad she's out of office. George Zimmerman, excuse me. So I want to play, let me see if I can play that clip. Yeah, but Barry Sorrells was the DA, by the way, who called David Armstrong a foot soldier. I'm trying to see if
I don't know if they're going to go into her chambers, but thoughts on what's happening here? It's kind of a surprise.
Yeah, it's not atypical. If I had for these type of breaks or unexpected, so if the defense is not happy now with the testimony that their experts are limited to, they've made the decision it's probably not worth putting him on the stand and subjecting them to cross-examination by the prosecution. And so if they can't get in the meat of the coconut on the points they wanted to make, then let's don't put them on the stand and let the prosecution make some points. And so they've probably told the judge that they intend to rest. Now, going back to her management of the case, it makes perfect sense at this point that she would take a break, and I'll tell you why. To serve as a juror, you're the exclusive judges of the facts that you hear from the witness stand as to what's to be believed, what witnesses are to be believed. What you hear, you judge the credibility of the witnesses. What the true facts are, that's your decision. But you don't, the facts get applied to the law, and we don't expect jurors to be lawyers. And so the court, the judge, at the end of the case, gives the jury, before they go out to deliberate, all the law that they need to know that under the facts and circumstances apply to this particular case. The judge reads, it's called the court's charge, which is basically, okay, jurors, you're the judges of facts. I'm the judge that tells you what the appropriate law is that applies to this case, and I'm going to read it to you. You're going to be able to, it's called the court's charge. You take it back to the jury room and use this as a guide, a legal guide, to measure your verdict and the decisions that you make with respect to the facts. It's complicated determining what the proper charge should be. There's a lot of possibilities on what goes in that charge. Both sides are going to have whatever their job is. Believe me, I couldn't do it, I'm sure. And it's hard for you to know how to be a lawyer by watching this show. But so I'll try and be as concise as I can. There's two.
Hey, Rebecca. He had been armed and he had shot and killed her, thinking she was the intruder.
Yeah. Well, we'd probably be, flip the script. We'd probably be having, or might be having, a similar trial. Maybe not. It would depend upon the details, facts, and circumstances of that situation. But it's possible that he could have been charged and we've been in the same situation.
We've got Rebecca Lopez.
And the way lawyers act and judge the jury of citizens with no interest in the outcome,
Okay, I was trying to find that clip. It's probably not there, guys, but basically that was Barry Sorrells, and he's a criminal defense attorney. They've been bringing on different defense attorneys, sitting down with the news reporters for WFAA. So that's how I've been watching the trial. And what he was just talking about was how the jurors were the triers of fact. The judge is going to present them with all of the evidence that's needed, the law that's needed, and they're going to apply the law and facts with the law and the facts or the evidence in this case to see what appropriate, if any, verdict they can render. So we will see what happens. But for David Armstrong or Craig Miller to try and stand in and say that she was not guilty or did not commit any crime, as David Armstrong is saying, you weren't fucking there. How could you say that? How can these guys? I can't see how these guys, and this is why the judge limited their testimony. They can't say for a fact that her mind state or get into her shoes and get in her mind on that date that she knew the difference between right and wrong or that something justifiable happened. Everything she has stated has been contradicted by testimony, even from both of John's neighbors. The neighbors talking about how they heard voices, and they heard one voice say, open this door. This is what one neighbor, it was a man, I believe he stated. He talked about how he knew both of John's voice because he sings all the time. He was a gospel singer at his choir, very active in church. And the repulsive things that I gather, especially out of this whole trial, what has been frustrating is how they try to demonize this brother over this marijuana stuff. He could have had a house full of drugs. That didn't give a right for someone to come into his house and kill him. Period. Now, we're going to wait and see what the facts say, but there was no gun found on him. And something else that was interesting is that as the defense attorneys, cross-examined her and she started crying, quote unquote, she did say she intended to kill him. So that may throw manslaughter out of there, because with self-defense, you're not stating with self-defense and what you're claiming that you killed this person for the purposes of saving your life. So you intended to do that. Of course, being that it, when you talk about manslaughter, it's at a point where there's a heat of the moment. Like for example, I'm just gonna give you guys examples of it. If I walk into my house, and I saw my wife buck naked with another man, and I grab my gun and shoot both of them, I can make a defense for manslaughter, because something like that would get you all riled up and emotional to the point where you don't think. But and perhaps that, and you know what, that might be something. Maybe defense attorneys, I think the defense attorneys are not, well, they're definitely not looking at that. They're looking for a flat out acquittal based off, the arguments that they have put forth. But, I'm glad that the Judge Kemp, did not allow that testimony from Armstrong about how he believes or knows that she didn't commit any crime. That's not for him to say. That's for a jury to decide. Whether her actions were reasonable. Yeah, that's true. They do try to demonize us. Well, anyway, guys, that's all I want to talk about. But check out the WFAA channel on Monday. That's when the trial will begin, restart. Uh, you guys have a great night. Enjoy the rest of it. I think I'm going to go out and do some driving or whatever. Anyway, guys, that's it for me. Peace and love.